A three-judge bench of the Supreme Court comprising Justices D.Y. Chandrachud, L. Nageshwara Rao and Ravindra Bhatt today allowed Vedanta to operate its oxygen manufacturing plant in Thoothukudi, Tamil Nadu to meet the growing demand of oxygen supply in the wake of the second wave of COVID-19 all across the country. The bench has clarified that Vedanta will not be allowed to enter and operate the copper smelting operations in Thoothukudi plant. Supreme Court also heard senior advocate Colin Gonsalves appearing for the victims and the families of the victims who had suffered due to the Vedanta's copper smelting operations in Thoothukudi. Following this, the Supreme Court has today ordered the Ministry of Environment to form a panel of environmental experts to gauge environmental concerns in the area, and so that the committee or the supervising committee which has been formed by the Supreme Court can have discussions with the environmental experts as and when need be. At one point of time, when Solicitor General of India Tushar Mehta stated that he supports the contentions and arguments put forth by Senior Advocate Harish Salve appearing for Vedanta, Senior Advocate C.S. Vaidyanathan appearing for Tamil Nadu government said that was not a proper statement to make and that centre should not support an industrialist like this in court. To this, the Supreme Court has clarified that this was not a case of political bickering and that the nation was in a crisis and that the court would help the nation at this moment of crisis. Well, in the Suo Motu case concerning COVID-19 issues across the country, this bench, headed by Justice D.Y. Chandrachud, has today clarified that the intention of the court to assume jurisdiction in this particular case was not to supplant the jurisdiction of the High Courts as assumed under Article 226. Justice Chandrachud has clarified that under Article 226 of the Indian Constitution, the High Courts have the right to not only protect fundamental rights but also legal rights, compared to which under Article 32, the Supreme Court can only protect fundamental rights. This justification came in the face of intense criticism which followed the initial Suo Motu COVID-19 order led by former Chief Justice of India S.A. Bobde, wherein members of the bar had expressed apprehensions as to how can Supreme Court transfer the cases pending in several high courts to itself. In fact, Justice Chandrachud has gone on to say that the Supreme Court in this case will help the high courts in issues which travails its boundaries. In other story, the three-judge bench headed by Justice D.Y. Chandrachud has today asked the central government to explain before the court the basis and the rationale for the pricing of the vaccines, of the COVID-19 vaccines in the country. The bench of Justices Dr. D.Y. Chandrachud, Justices L. Nageshwara Rao and Ravindra Bhatt noted that different vaccine manufacturers were quoting different prices for their vaccines at a time when the country is going through a national crisis. Justice Bhatt said, regarding pricing on vaccination, different manufacturers are quoting different prices. There are powers under the Patents Act. This is a pandemic and a national crisis. Solicitor General Tushar Mehta submitted that an affidavit or a reply was filed by the central government which could not be circulated this morning. Some of the highlights from the operative portion of today's Supreme Court order is primarily that the central government has to apprise the top court about the availability of the total amount of oxygen in the country and the projected demand of oxygen in the country that is about to take place. And with regard to vaccination, not only the government has to substantiate the rationale and the basis of the pricing of the vaccination, and also how the government would meet the growing demand of COVID-19 vaccination, especially since after 1st of May, every individual above the age of 18 would be eligible for the COVID-19 vaccines. The court has further ordered that the modality to be put in place to ensure that shortage and deficit of the vaccines would be looked into would be submitted before the court. A comprehensive panel of doctors should be made available to the citizens to know steps to be taken during the pandemic. The central government has been asked to apprise the court about the steps taken to form an identified panel of specialists which will be replicated at all state levels. The initially appointed amicus curiae, Senior Advocate Harish Salve, had sought to recuse from the case and his recusal was allowed. Today, the Supreme Court appointed senior counsels Jaideep Gupta and Meenakshi Arora as the amicus curiae in this case. All states and union territories across India have been directed to furnish a reply to the Solicitor General of India, Tushar Mehta, by April 29, 6 p.m., stating the availability and the plausibility of the infrastructure in the state regarding the directions given by the court. The Solicitor General of India will compile all these submissions and also put in place his additional affidavit, a memo, or a written note and submit to court by April 30th in the afternoon. The case would now be next heard on April 30th, Friday at 12 p.m. The Uttar Pradesh government on Tuesday took strong objection to the Chief Justice of India, N.V. Ramana-led bench hearing the habeas corpus petition moved by Kerala journalist Siddique Kappan for his release. The Uttar Pradesh government primarily submitted before the Chief Justice of India-led bench that his detention was as per procedure prescribed by law. Solicitor General of India, Tushar Mehta, primarily argued that the present interim application seeking the transfer of Siddique Kappan from a Mathura hospital to the All India Institute of Medical Sciences, New Delhi, was not maintainable since the primary habeas corpus petition was also not maintainable as per law. Supreme Court has now asked the Uttar Pradesh government to furnish the medical records of Kappan by today evening and that the case will be listed tomorrow. The plea by Kerala Union of Working Journalists primarily stated that Kappan had collapsed in the Mathura hospital after he was diagnosed with COVID-19, and his wife made a further application seeking his release back to the jail, stating that Kappan was chained to the hospital bed by the officials. A three-judge bench of Chief Justice of India N.V. Ramana and Justices Surya Kant and A.S. Bopanna today relaxed the limitation period to file cases under all general and special laws across the country from March 14 until further orders. Chief Justice of India N.V. Ramana primarily noted that the COVID-19 pandemic had caused an alarming situation in the country and litigants were suffering hardships. In view of this fact, the Chief Justice of India today ordered that all the limitation period, which was relaxed till March 13, 2021, which stood relaxed until March 14, 2021 too, was going to be extended until further orders. Initially, the bench was of the view that the limitation should only extend up till July 15, 2021. However, Attorney General for India K.K. Venugopal suggested to the bench that it should be until further orders in view of the second wave of the COVID-19 pandemic. Well, that's all from Supreme Court today. Do stay tuned with Supreme Court today tomorrow as well. And don't forget to like and share BarAndBench.com.